Be cool, be kind, be classy. The cupcakes are sweet and sexy. Have fun and enjoy the journey. Or just have a good attorney. No big whoop, no biggie. She lives near New York City. And not just a YouTube show. When you know, you better grab a straw. Learn about the law. It's cool here in the shade. Sipping motions of lemonade. Cool heads will prevail, kindness will never fail. Be classy and vastly wise. Oh, Melanie Little is going live. Oh no, where is Melanie? Follow the island's melody. There's a concert within reach. No surprise, she's at Jones Beach. She heard some music far away. Captain Jack's at Harbor Bay. He sings and his piano plays. Not all sounds are waterways. Speaking Yiddish and Latin, it's not just for Manhattan. It's for Goethe and Machegas. Ridiculous that insanus. Oy vey, Marcus. Proset, that's for schmucks. Be cool, be kind, be classy. A cupcake sweet and sassy. And not just a YouTube show. When you know. Cool heads will prevail. Kindness will never fail. Be classy and vastly wise. Melanie Little is going live.
Hi. Oh, good morning. Good morning. Happy Tuesday. Happy Tuesday. Today's Tuesday, June 23rd, 2026. I don't know. What should we call it? Toxic Tuesday? Well, we waited yesterday for many hours for the court hearing on the motion to compel Colin Albert to appear for deposition in Plymouth Superior Court, Massachusetts, in front of Judge Gilday. And Boston 25, CBS Boston, had its camera set up in the courtroom. The courtroom was changed. It was supposed to start at 3 o'clock. And then I don't know what had happened, but our girl Boozy Beauty was in the courtroom and then she was done. And the live stream never aired. In fact, while we were watching, CBS Boston just pulled down their stream and it said video unavailable. And what happened last night? Last night it popped up on the internet. Canton Community TV put it on their website. And now Trial Channel has it up. So we're gonna watch it together. It's only about 45 minutes long. Chris Maddie showed up because, as we know, Jimbo Tuxbury was on vacation. And so Chris Maddie showed up. He's the attorney who sued Alex Jones and got something like $1 billion verdict between a couple of the cases that he had against Alex Jones. And I don't know if any money was ever collected or anything, but Chris Maddie says it's very unfair. It's very unfair to Colin that he should have to leave his boot camp training to come and appear for a deposition. And we're going to see how Judge Gilday responded to that. Couple new things. Thank you, Kyle Sharkey, for sending this to me. Although I don't have the papers because the papers are not available yet. This is in the Aiden Carney case. This is in Commonwealth versus Aiden Carney. This is a new filing as of this morning. This is defendant Aiden Carney's motion to impound unredacted copies of supplemental motion to dismiss affidavit and exhibits. So that's docket number 140. Hang on, because there was another entry, I believe, after that. And then there is docket number 141, which is defendant Aiden Carney's second motion to compel disclosure of Michael Proctor's communications with incorporated memorandum. So apparently Aiden's team, Tim Bradle, Mark Betterow, filed a second motion to compel disclosure of Michael Proctor's communications. And then the memorandum, there's a motion to impound unredacted copies of the supplemental motion to dismiss affidavit and exhibits. Okay, so there's a motion, and then there's exhibits and the affidavit of the attorney, and they want that to be impounded. the unredacted copies to be impounded. It's a little bit confusing, but it's really not. So we're not really going to get to see anything. Oh, there's Charlie Deloach is still in the corner from yesterday with his eye roll. He's the jury foreman from the Karen Reed trial number 2. And we watched his interview and his eye rolls were classic. Why would they want it to be impounded? Because it's going to contain certain messages of Michael Proctor, I guess, that have not yet been released to the public. That's what I don't know. Until I see the papers, I can't really opine further than that. I don't have the papers yet. So there's that. But they want that part impounded because it's going to be unredacted. And they're still trying to get Michael Proctor's communications, which they don't have a full phone extraction of Michael Proctor yet. But I imagine, since it's being freely given to many other defendants, that it will too be freely given to Aidan Carney and his team. So before we move on to watch yesterday's hearing that we missed because they pulled the plug on it, let's read today's motivational quote of the day for Tuesday, June 23rd, 2026. Oh, it's another quote from George Washington. Human happiness and moral duty are inseparably connected. Human happiness and moral duty are inseparably connected. Thank you, George Washington. There you go. All right, well done to you. Let's see. We also need an empowerment card today. I mean, an affirmation. An affirmation for a badass is what this deck is called. Good morning, everyone who's tuning in from everywhere. Thank you to all of my friends from across the pond who are sending me all of your London suggestions and things to do. And then I went to check in for our flight this morning, and now I realize I need to get a visa. I need to get a visa to really literally go there for the weekend. What? That's a whole other procedure I need to go to. I didn't know that. Also, do I need to go to the bank here and get some currency? I'm used to going to Mexico where they love when you tip in American money, so I never have to worry about getting pesos because you have to order pesos from the bank here, and it takes like a couple of days to a week to get them. Tell me, my friends in the UK, it's not that late. What is it, 3:45 over there? All right, here you go. Here's today's affirmation for a badass. Ready? Me. I'm getting better and better every effing day. If you needed to hear that, I'm getting better and better every effing day. And that works whether you're healing from something or whether you are, starting something new in your career. You're getting better and better every effing day. You heard it right there. I don't know. I only want to hear from people who are in London who actually really, really know the answer. It's some sort of government ETA, like electronic visa for visiting there. And maybe it's a new thing. You can do it over the government website. I don't really know. I'm used to going to Mexico. That's where I go. I don't really go too far out of the country. I've been to France a couple of times. I've been to Paris. I've been to Italy. But I've never been to the UK. So this is a little new to me. And, who knows? They keep on changing requirements like for everything nowadays. It's a new thing. Somebody said, yeah, it's a new thing. I made sure that the place we're going to has air conditioning because I know it's really hot over there. But listen, I'm from New York. We're used to the really hot and humid weather here too. So I think it's going to be fine. It's a new thing. You can use your credit card. No, I understand, but I like to tip people in cash. Can't tip people with a credit card, right? I'm a tipper. I enjoy tipping. I like tipping. I know what it's like also to be a waitress because I was a waitress while I was throughout high school and while I was in college and studying for the bar exam. And so I understand the importance of leaving your job with a little cash in your pocket at the end of the night. And I try to tip in cash whenever I can, because if you tip on the credit card, it's like a lot of restaurants don't tip out their waitstaff at the end of the night. They have to wait to get it in their paycheck. It's ridiculous. It's withdraw cash from the ATM. All right. Let's go to Let's watch the child channel coverage because it's on YouTube, and that way, if we need to, I can boost it. Although I do want to shout out Canton Community TV, who did post it last night, but it is on their own website, and so therefore, I can boost the volume if need be. My booster is for YouTube only. Okay, all right. Let's go there. If the papers of Aiden Carney's motion wind up in my inbox, we can cover that as well. But as of right now, I don't have them. So who knows when they'll get scanned in and yada, yada, yada. Other interesting information, and we will look at this afterwards. Looks like Tully has become, he's teaching a course on digital cell phone forensics. Are you kidding me? Get your snark ready for that, because we will talk about all the reasons, all the things that Tully missed in the investigation into the murder of John O'Keefe, and why it's a ridiculous even proposition or even fantasy of Brian Tully's that he should be teaching anybody how to do anything involving proper investigative techniques. I mean, are you kidding me? All right. Let's go first to yesterday's hearing. And yesterday was June 22nd, 2026. And we will go there. Thanks for all of your comments in the chat. I usually do go back if I can and scan the chat after the show is over. So if you're putting any really good tips in there for me for London, I do love a good castle, but I only have like really 2 full days to run around and do stuff, and then the third day is prepping for the Harry Styles concert, and all my daughter cares about is where the Brandy Melvilles are in London. So that's what we're going to do, I guess. Shop, I don't know. All right, here we go. There's Judge Gilday on the bench. And I'm not sure who this court clerk is, the female in the black dress with the white trim around her sleeves, but I love her voice. She's got a great court voice. I really like her. I don't know if you hear Mastad, but if you are, let me know if you know this court clerk and if you like her, because she seems really nice and really cut out for the job. Okay, today's going to be our introduction to Chris Maddie, famous, high-powered attorney. And he's going to tell us why it's just not fair. It's not fair that Colin should have to come back from boot camp and ruin his boot camp experience. And the judge is going to tell us that Colin's burden is self-imposed. He already had a subpoena served on him before he decided to enlist in the Army. And, a subpoena needs to mean something, right? He loves to say that. A subpoena needs to mean something. All right, if anybody comes in and they're like, what is it that we're watching? Please refresh their recollection, because the title of the stream actually says what it is, and I can't be stopping every 30 seconds to catch people up in the chat. So I'd like you guys to do that for me today. Okay? Thank you so much. I love it, even though you always do. All right, here we go. You haven't missed a thing, because this hearing is about to start from yesterday. Thank you, Fairy Raven, for gifting a membership. You're amazing. I appreciate you so much. And as did PMED9EW, also gifted a membership. Thank you very much. All right, here we go.
83CV00692, Paul O'Keefe, individually and personal representative of the estate of John Joseph O'Keefe III, et al. Versus CNC Hospitality, LLC, doing business as CNF McCarthy's et al. Counsel, if you could please state your name for the record because that was plaintiffs.
Good afternoon, Your Honor. Dan Buck on behalf of the plaintiffs.
Good afternoon. Good afternoon, Your Honor. Aaron Rosenberg on behalf of defendant Karen Reed.
Good afternoon.
Good afternoon, Your Honor. Sarah Shipley on behalf of the defendant Karen Reed.
And good afternoon, Your Honor. Chris Maddie on behalf of non-party witness Colin Albert. I'd like to thank the court for its consideration of allowing me to participate.
Oh, look, there's Peter Murphy. Looks good. Kill Peter Murphy. Peter Murphy's on the end in the navy blue polo shirt. I'm not sure who the other people are there. I don't recognize anybody else. Karen Reed is not there. Family's not there. And I don't think any of the Haas defendants are there, but here's Chris Maddie. And remember, he said it was very expensive. Tuxbury said it was very expensive to file a pro hoc vice application in every case. So they did not file one for him to be there today. Pro hoc vice is when you're not admitted in a state and you need to be admitted into the state for the purposes of each case that you would like to represent someone on. So while Chris Maddie is from Connecticut, and he did file a pro hoc vice application in the defamation case to represent the Haas plaintiffs, including Colin Albert, he has not filed a pro hoc vice application in this case to represent Colin Albert's third-party interests or non-party interests to force him to come in for a deposition. But the judge is going to allow him to speak anyway, which is something that I'm sure Judge Cannoni would never, ever do, right? So listen to him to explain to the court that he's not pro hoc in.
Of non-party witness Colin Albert, and I'd like to thank the court for its consideration of allowing me to participate today, even though I'm pro hoc in on the defamation case and not on this one.
No problems, without objection, correct?
Correct.
They're not objecting, and that's the nice thing to do. And it's really expensive. It's like $350. Okay. Plaintiffs' attorneys spend tons of money on everything, all the expenses. They don't bill by the hour. He's a defendant here in this case, so maybe that's why it's really expensive. But that was such a ridiculous statement that he made. If you can't afford $350 as a plaintiff's lawyer, you're not raking in the money like most plaintiffs' lawyers. So I don't know what to tell you.
So does the email you sent this morning, Attorney Rosenberg, to the clerk reflect the present status of the parties?
Yes, Your Honor.
Okay. And with respect to, I mean, you basically have two categories that are the subject of discussion, correct? The communications with the deponent's parents would be one category, and then the other one would be communications with others.
Yeah, that's not exactly how we'd been discussing it last, but I see how you're saying that. Yeah.
Okay. And then in the email to Attorney Maddie today, or I don't know when it was, I guess it was on Friday.
Yeah, Friday, I think.
You reference a date range of January 28th, 2022 through December 31st, 2023. What category does that relate to?
So it would relate to both in part. So as you know, we originally had,
Just tell me.
well, it would relate to for the non-parent category. Start with that. It would relate entirely to that.
Okay.
And then for the parents, there are two separate proposals we made. One was
A and B in the email.
correct. So it would apply to B in that email as well. So it would apply to everyone.
Okay. And then are the communications that you talked about, the period of January 28th, 2022 through April 30th, 2022, which were a subset of the parent ones,
Correct.
are those limited by the which relate to language?
No, and there was a reason for that. So obviously one of the disputed issues, as you can see in the papers, is Mr. Albert's timing for being at and then departing 34 Fairview. We believe that we're entitled to discovery that encompasses communications around that fact. And there could be, and I would imagine would be, communications in the immediate or close to immediate days or months after an event like this between close family members that would reflect those movements and would be relevant to those movements. However, we recognize that asking for every communication between a parent and their son can't be years. It can't even be the year, 2 years that we've limited ourselves to. So what we're trying to do is have a much smaller scope where we request all communications. Obviously, if there's attorney-client privilege or something like that, that is, they can make that claim. But we're requesting all communications within a very small period of time. And then the parents would be lumped back in with everyone else for the remainder of the period through December 31st, 2023.
And that small period of time is what?
Our last proposal was January 28th, 2022 through April 30th, 2022.
And why do you suggest it should not be limited to the issues otherwise identified?
Because let's just take, for example, that there's a communication about when you got picked up. That wouldn't relate necessarily to the categories that we have listed here, right? The death of Mr. O'Keefe, the investigation into Mr. O'Keefe, I would say it's relevant, obviously, but you could see communications about timing, who was driving, how they knew to go pick you up, et cetera. I'm just giving you examples now, but things that would not otherwise fall within that category. And we're not asking for that with everyone, but we are asking for it as between Colin and his parents.
But you don't believe there's any way to limit the scope of that request to other than all?
We could try to limit it to say,
Well, I take it if you haven't communicated since Friday afternoon, you haven't been trying, right?
well, as you saw in the communication, I haven't been trying, correct? Because I made a final proposal on Friday that you just referred to, and the response I got was we're comfortable with our last proposal.
Let me hear, Attorney Matter.
Yes, Your Honor, and I'm maybe at a bit of a disadvantage because
Okay, this is Chris Maddie. Aaron Rosenberg says we gave you a final proposal on Friday. Judge is like, you haven't spoken since then. Remember, this was Monday. So no, Friday also was a federal holiday. It was Juneteenth. And this is just a lot of squabbling back and forth about what documents and what communications Colin Albert should have to produce. It seems to me like they narrowed it down greatly between, I think their initial ask was between January 29th, 2022 and the present communications between Colin and his parents, Julie and Chris Albert. Then they were willing to narrow it down to January 29th, 22 to April 30th, 2022. It's a 90-day period, but he doesn't want it limited to search terms. Like Colin Albert was only searching terms such as John O'Keefe, Karen Reed, and things like that. He says he wants all communications because it's the time that he was at 34 Fairview, the time that he got there, the time that he left. That's what's very important here. This is the first time we've heard, I think, Christopher Maddie speak in court in this case. So let's listen to what he's got to say.
So let me hear, Attorney Matter.
yes, Your Honor, and I'm maybe at a bit of a disadvantage because I don't believe I was copied on the email correspondence this morning. And if I wasn't, if I was, please correct me, Attorney Rosenberg. But I don't think I was copied on.
Yeah, that's my fault. Your co-counsel was. I apologize.
I'll tell you what, it'd be helpful if you went and familiarized yourself with it. So why don't we get a copy?
Yeah, here you can.
Right? We'll take a short break. You didn't have to read it in front of everyone.
But it was just forwarding.
We'll take a short break and let you read that so you're up to speed like everyone else is.
Thank you, Your Honor.
All right.
All right.
I mean, come
Get
on.
a chance to look at it?
I get Your Honor.
Is it really hard to copy everyone on an email? It's like, come on. So then they stop the hearing so that he can review the email, which was really just a bunch of forwarded emails. And thank you, Trial Channel, for cutting out the break, as did Canton Community TV, because nobody was allowed to stream this live, including Boston 25, who was actually in the courtroom with their setup.
Yes, and it was just a transmittal email that included the rest of our correspondence, so I'm comfortable with that.
Okay. So what do you say to whether or not the scope of the request for that limited time period could be reduced from everything to something less?
Yes, Your Honor. Our proposal, which we made to defense counsel, we thought was quite broad and actually should capture information concerning, for example, Mr. Albert's movements on January 28th. What we suggested was that,
Well, they didn't take it that way, I guess, right?
well, they may not have, but what we suggested, and perhaps the court, you can tell me if you think this is fairly broad in scope, but what we've suggested is,
Right now, it doesn't matter what I think. What matters is what the two of you think and what you can agree to.
so our belief is that anything that Mr. Albert may have, any communications or documents that he may have relating to the facts and circumstances of Mr. O'Keefe's death or the law enforcement investigation into Mr. O'Keefe's death would encompass any responsive material that would be relevant to this matter. And we're willing to do that. We're willing to do that for a 3.5-year period. And we're willing to do it with respect to every individual that they've asked for communications to or from. And so this, to me, is a little bit of a situation where Ms. Reed won't take yes for an answer. We're actually agreeing to provide anything that we may have related.
Ms. Reed won't take yes for an answer. He says he's willing to give everything for a 3.5-year period. That's generous from all of the people, including Nicole Albert, Brian Albert. I'm not sure who else they requested it from. Nicole Albert, Brian Albert, Jennifer McCabe, Matt McCabe, Brian Higgins. Let's hear that again. Somebody said, how would they know to loop him in when he's not normally on this case? That's a good point. And you're right. He didn't file a pro hoc vice in this case. So maybe they didn't know that he was in on this case. And again, this is the wrongful death case of the O'Keefes versus Karen Reed. And in this case, Colin Albert's a non-party. He represents him as a defendant in the federal case that they removed to federal court that Karen Reed filed against them, and also in the defamation case. So that is a good point, Carol. You are right. Do that again.
To or from. And so this to do that for a 3.5 years into Mr. O'Keefe's death would encompass any responsive material that would be relevant to this matter. And we're willing to do that. We're willing to do that for a 3.5-year period. And we're willing to do it with respect to every individual that they've asked for communications to or from. And so this, to me, is a little bit of a situation where Ms. Reed won't take yes for an answer. We're actually agreeing to provide anything that we may have relating to the facts of John O'Keefe's death, which is the central issue in this case, or the investigation into his death, which, as I understand it, would encompass what Ms. Reed has claimed is a false narrative surrounding, what the plaintiff would claim is her false narrative surrounding that death. So we are comfortable that frankly, that we've kind of bent over backwards to include a 3.5-year time period of two very broad categories. I offered to discuss search terms with counsel that we could agree to in order to come up with materials that might be responsive. And so, for example, if counsel felt that the category we've suggested would not encompass the timing of when Mr. Albert left 34 Fairview, the way around that is just to agree to a search term that would capture those communications, because we have no objection that those would be responsive and within the category we've suggested. But what we object to is a unscoped request for materials, particularly relating to communications he may have had with his parents, and the very, very broad categories that seem designed to capture information that is not relevant to the issues in this case.
I mean, why is he objecting to any more communications between him and his parents? Those aren't privileged communications. There is no parent-child privilege. There's a spousal privilege and an attorney-client privilege, but there's a doctor-patient privilege, but there's not a parent-child privilege. And as somebody pointed out here, I bet you they were talking in code, so the search terms aren't going to do it. And if they're only willing to provide stuff that had to do with the death of John O'Keefe and the investigation, that might not do it either. Because remember, we've seen group text messages between them where things are said such as, tell them the guy never went in the house. Well, that wouldn't come up under any search term, right? It doesn't say John O'Keefe, it says the guy. And then Nicole, I think, said to Jen at one point, I don't want to text about it. We'll find out more tomorrow. Well, that wouldn't come up in any of these search terms either, right?
Which, as I understand it, are one, the facts and circumstances surrounding Officer O'Keefe's death.
Hang on.
Yep.
Give him a chance to respond.
Yes, sir.
You take it.
Yeah, I'm actually going to address what I think Mr. Maddie was about to address. This case isn't just about what happened to John O'Keefe. That's part of the wrongful death claims that the plaintiffs have alleged. But as your Honor is aware, they have these false narrative, intentional infliction of emotional distress, negligent infliction claims, which relate to, as they call it, the false narrative. That includes the investigators, the investigation, and what Ms. Reed said in both her criminal trial and her other statements, that something happened to Mr. O'Keefe within the house. That is the false narrative. So it can't be limited to just the death of John O'Keefe. I'll give you one example. If Colin Albert had sent a text about Karen Reed, but not about the death of John O'Keefe and specifically the circumstances, I believe that's well within the scope of discovery in this case, and it would be excluded by what Mr. Albert's counsel has proposed. Similarly, if Mr. Albert said something about his relationship with investigators, which is a main part of that quote unquote false narrative in this case, and that Mr. Albert himself is suing Ms. Reed about, that necessarily wouldn't have been included. So it needs to be broader. I'm more than happy to work on search terms with Mr. Albert's counsel. In fact, I think that's a very efficient way to do that. But we need to either agree on, which we haven't been able to, or establish through Your Honor what the scope and the categories that are rightfully at play here are. And then I'm more than happy to work with them on search terms immediately to get to those categories. But I think you can hear that we've still got differences here. And this is not unscoped. You can see we proposed terms, we limited it from the subpoena. There are specific topics that we're asking for, not even of everyone, but only of certain individuals. And those topics are Miss Reed, Mr. O'Keefe, the investigation, the state police and Canton police, the Norfolk DA, and the U.S. Attorney or DOJ. That's not everything under the sun. And to the extent there are categories or individuals where Mr. Albert has none, as I've said repeatedly, we will accept that. If counsel represents there were no documents as to, individuals A through D, then we're done with those. In addition,
Well, a good attorney never asks a question that he or she doesn't already know the answer to. And so he's saying, listen, if you say you don't have it, if you say you don't have any communications between Colin and Proctor, great. Just say you don't have any. But you got to remember, they have Proctor's phone extraction. So they've got one side of these conversations. And who knows if there's group text messages in there with, Proctor and, let's say, Brian Albert, Matt McCabe, Jennifer McCabe. They've got those too. So if these people come in and say, we don't have any of that stuff, we don't have it, and they've got it from another source, they're going to have some splaining to do.
if there was some extreme burden, right, there was one term or subject matter that was bringing back thousands of messages and it was going to be burdensome in order to go through and produce those, we would have considered that. But we haven't heard any of that in the communications or in the multiple hearings we've now had. It's just this overall, this is too broad. And we heard, Your Honor, about the time scope. We cut it more than in half. We addressed the terms, but at a certain point, we're entitled to the discovery that we're seeking pursuant to our subpoena.
May I respond briefly, Your Honor?
Absolutely.
So on the false narrative claim, what Ms. Reed apparently wants to present as a defense in the wrongful death case to the emotional distress counts is that what she said was in fact true. Whatever she claims happened inside the house, to the extent there's any evidence at all that she is at some point going to present to this court, then that would be captured by precisely what we've proposed, the circumstances surrounding John O'Keefe's death. So let's just take a parallel universe where Mr. O'Keefe, as Ms. Reed alleges, went into the house and something happened there.
We are in a parallel universe, sir. We call it the upside down, inside out, Twilight Zone Narnia of Norfolk County. Because here's what happened, counselor. On January 29th, 2022, in the early morning hours, there was some paranormal activity in and around the area of 34 Fairview Road, because all of a sudden, people started butt dialing at each other back and forth, and the phones were hanging up before they got to voicemail. Google searches were mysteriously appearing on people's phones at 2:27 in the morning, where someone may or may not have been Googling Hoslong to die in cold. The paranormal activity that was happening in and around 34 Fairview in the early morning, it was wild. I mean, there's dead zones and allegedly a woman backing up at 24 miles an hour for however many feet they finally landed on, hitting John O'Keefe with their car. No tire screeches. Nobody heard a damn thing, even though everyone's curtain twitching out the window. They're curtain twitching out the window at 12:45 when they see Karen's car still there. We know she connected to the Wi-Fi at One Meadows at 12:36, and nobody saw a body on the lawn. I mean, that's what I call a parallel universe. And yes, if they're going to accuse her of creating a false narrative, she's got to show that what they allege was a false narrative, that John O'Keefe was not hit by a car and that something else happened to John O'Keefe. She's allowed to be entitled to prove that. And one of the ways that she can prove that is by obtaining communications from your clients, because he represents all of them, shockingly, to see what other sus behavior was occurring aside from all of this paranormal stuff in the early morning hours of January 29th, 2022, and after, up until the present day. We didn't see any messages where they were mourning the loss of their dear friend, Boston police officer John O'Keefe, or trying to figure out what had happened to him and how he died. But we did see a lot of tell him the guy never went in the house, and a lot of surveillance of Matt McCabe saying, oh, the MSP is there again. They're at the Asian house. Tell Chris to ask some questions of the reporters. It's crazy. So yeah, listen to him talking about a parallel universe. Remember, these are the big guns that they hired, and he's not cheap, I'm sure.
Evidence at all that she is at some point going to present to this court, then that would be captured by precisely what we've proposed, the circumstances surrounding John O'Keefe's death. So let's just take a parallel universe where Mr. O'Keefe, as Miss Reed alleges, went into the house and something happened there. If Mr. Albert has any documents relating to that parallel universe, it would be captured by exactly what we proposed. Because what we are proposing to do is to provide any documents, any communications concerning the circumstances surrounding John O'Keefe's death. So that's number one. With respect to their claim that they should be entitled to any communication about Miss Reed, Mr. Albert was and is a victim in a criminal case that's been brought against Eden Kearney. That, as I understand,
he's a victim of T-Rex arms and window intimidation. He's a victim. These people love to play the victim. We played yesterday, and the day before, Chris Albert's tone-deaf speech from the Juneteenth gala for the Haas defendants. You know what I didn't see? We saw the big poster of all the sponsors of the event. Nobody used their real name except for one person. And he talked about how what happened to Colin should never happen to anybody else. It's the biggest travesty, the worst thing that's ever happened in the world. There was no poster board picture of John O'Keefe there, and justice for John O'Keefe. I don't know, were the O'Keefes even there? Or was this solely a fundraiser for their legal fees to pay this guy? Colin Albert's a victim. He's going to use that theme throughout. It's not fair to Colin. It's not fair to Colin. So just put a pin in that for now.
Mr. Albert was and is a victim in a criminal case that's been brought against Eden Kearney. That, as I understand it, Miss Reed was at one point a subject of as well.
It's Kearney.
She was not charged.
Kearney.
But I'm highlighting this as an example of why Mr. Albert might very well have communications about Miss Reed that have nothing to do with the issues in this case.
Oh.
They would want us to produce a...
Wait a second. So you're saying that Colin Albert might have been talking in his phone about Karen Reed, but it has nothing to do with the murder of John O'Keefe? Why would Colin Albert be involved in any conversations trying to get Karen Reed indicted with Eden Kearney for conspiracy to commit witness intimidation against him? That's a very interesting statement to make. There very, very well may be communications about Karen Reed that have nothing to do with the murder of John O'Keefe. Why? Why would there be? From Colin Albert? All right. He's a victim. I want to hear that again.
Communication with the issues in this case. They would want us to produce a communication in which Mr. Albert pointed out that Miss Reed had a dog or a cat, which has no relevance to this case. Or that Miss Reed...
Wait, a dog or a cat? Hold on. Hold on. Are you going to say that Ms. Reed had a dog and then maybe her dog attacked John O'Keefe's arm? Is that going to be your theory? So there are messages about Karen? Wait, rewind.
as well. She was not charged, but Mr. Albert was and is a victim in a criminal case that's been brought against Aiden Kearney. That, as I understand it, Miss Reed was at one point a subject of as well. She was not charged.
Right. They tried to indict Karen Reed and Aiden Kearney together, but that grand jury failed. The grand jury did not indict that ham sandwich of Karen Reed and Aiden Kearney. Saul Wackler, Chief Justice of New York, at one time famously said, a good prosecutor can get a grand jury to indict a ham sandwich. Well, not there in Norfolk County. They didn't.
But I'm highlighting this as an example of why Mr. Albert might very well have communications about Miss Reed that have nothing to do with the issues in this case. They would want us to produce a communication in which Mr. Albert pointed out that Miss Reed had a dog or a cat, which has no relevance to this case, or that.
Which one chewed up John O'Keefe's arm, the dog or the cat? Maybe it was a cat. Do you think those were cat scratches on John O'Keefe's arm? I forgot the paranormal activity of the ghosts, the apparitions appearing in and out of the Sally port, crazy stuff like that. How the camera inverted the Lexus. I mean, that in addition to all of the other paranormal activity, how the Sallyport video just went missing, disappeared, and then reappeared, even though they told the court that it overwrote itself every 30 days. Huh. A cougar, maybe. Enough snow to track a cat. Cat scratch fever. You guys are on it.
Miss Reed had launched a defamation campaign against him, which also has no relevance to this case.
Oh, yes, it does. Oh, yes, it does. Payback. Demon scratches. Maybe that's what it was. Maybe it was the paranormal activity extended to like a poltergeist. You know, like a Blair Witch kind of thing, or one of those other movies where people, people get scratched by spirits in the middle of the night. That's a great point, you guys. I mean, maybe that could be their theory. We didn't do it. The paranormal activity did it. There was some sort of conjuring that night, and there was a spirit that was conjured, and that's what happened to John O'Keefe. Right. Jennifer McCabe does have voodoo dolls, apparently. That's right. I forgot about the voodoo dolls. I'm a cupcake too. Who talked about the voodoo dolls? Lindsay Gattani said she went to Jennifer McCabe's house and there were voodoo dolls in her house in a bowl, a voodoo doll of Aiden Kearney and of Karen Reed. Is she in a coven? This just opens up the door to so many questions. I mean, if you thought the Odin theory and the Delphi cases were crazy, I mean, it hasn't even been brought up here. Hasn't even been brought up here, but maybe that's what they're gonna do. I don't know. Come into the light, Carolyn. Carolyn. They're back.
Has no relevance to this case. They misread that have nothing. She was not charged, but I'm highlighting this as an example of why Mr. Albert might very well have communications about Miss Reed that have nothing to do with the issues in this case.
Sounds like he does. Sounds like he's got some stuff on his phone about Karen Reed, but Maddie doesn't think that it's relevant. Because these are really weird examples that he's bringing up, right?
Want us to produce a communication in which Mr. Albert pointed out that Miss Reed had a dog or a cat, which has no relevance to this case, or that Miss Reed had launched a defamation campaign against him, which also has no relevance.
I don't think the words launched a defamation campaign would ever come out of Colin Albert's mouth, because how many times did he ask David Yannetti or Alan Jackson or whoever was questioning him to rephrase their question because he didn't understand the big words? So I highly doubt that Colin Albert said, Karen Reed has launched a defamation campaign against me. But it sounds like he's admitting, I don't know, something that maybe there's other stuff in there about Karen Reed, but he doesn't think it has anything to do with the case. So he shouldn't have to turn it over.
To this case, it may have relevance to some other case, but it has no relevance to whether or not Mr. O'Keefe, the circumstances surrounding his death, which again, we agree. Anything relating to that, they should get. Anything relating to the false narrative claim, which again has to do with the circumstances surrounding John O'Keefe's death, we've agreed to give that to him for a 3.5-year period. So I'm not understanding.
Rosenberg is over there playing Pop Goes the Weasel. If you can come to screen, come to screen. He keeps like getting up in his chair. He's like ready to Pop Goes the Weasel. Watch. He can't even. He's sitting on a slinky. Looks like. Look at this. Only if you're not driving or on scaffolding. Come to your screen for a second. Sometimes we need comic relief.
Anything relating to that, they should get. Anything relating to the false narrative claim, which again has to do with the circumstances surrounding John O'Keefe's death, they should get. We've agreed to give that to him for a 3.5-year period. So I'm not understanding yet why the very, very broad scope, which I think counsel would acknowledge, would necessarily result in communications that are not relevant to anything here. Why the court should bless something like that when what we've proposed, I think, broadly encompasses all of the claims in this case.
Just 2 quick points. One, the false narrative is not just about the death of John O'Keefe. The part of that alleged false narrative is the cover-up and conspiracy side of things. That necessarily came after Mr. O'Keefe died. So it's inaccurate to say that we can capture anything relevant to this case by stopping on January 29th, 2022 or thereabouts. Secondly, as we're all aware, this is a third-party subpoena. At a certain point, a third party is not in a position with standing to argue about specifics of relevance.
Right.
They have standing to argue about burden and undue burden on a third party. And we recognize that, and that's why we made changes. But a relevance objection like this is misplaced at this point. We are entitled to put document requests that, in a subpoena that are reasonably intended to gather relevant topics. I think a term that relates to communications about Karen Reed and about John O'Keefe is well within that scope, as Rule 26 uses the phrase relevance.
I'm not trying to get the last word, Judge. Just a couple of things I wanted to add.
Yes, you are.
Afternoon.
Yes, you are. The judge is like, we have all afternoon. I'm not trying to get the last word because Matty jumps out of his chair. And he's right. He's not a party to this action. He doesn't have standing to object to relevance, but let's see what the judge says about it.
As Rule 26 uses relevance.
I'm not trying to get the last word, Judge. Just a couple of things I wanted to add.
I got all afternoon.
First, if what she's claiming is that there was a grand conspiracy and a cover-up, okay, the date range we have proposed, to the extent there were any communications in furtherance of this conspiracy and cover-up, would more than adequately capture them. We're proposing a 3.5-year period. And so if, as Ms. Reed apparently purports to believe, there was a grand conspiracy that was occurring in 2022 and 2023, and there were communications about the circumstances of Mr. O'Keefe's death at that time, and the fact that all these people, dozens and dozens of people apparently were conspiring, then those will be produced in this case under the subject matter that we have scoped here. I also, just on the relevancy thing, we cited authority in our brief, Your Honor, that the party propounding the discovery has the burden of showing some relevance. And so this is absolutely an issue that the court should have to decide when considering what is an appropriate scope here.
I don't know if you want to argue that because the judge is more intimately familiar with the facts and circumstances on this case than I'm sure that he would like to be, because not only is he handling this case, he's also assigned to the defamation case in which you are the plaintiff's attorney. So let's not pretend that you didn't file a lawsuit against Karen Reed and Aiden Carney for defamation. And so all of this stuff is relevant. Whether or not it's admissible at trial is a question for the judge. But relevance is very, very, very broad in civil cases. This is not like criminal court where you have to pull teeth to try and get something. We saw Karen Reed's team filing 1 million Rule 17 motions to get stuff regarding third parties, most of which were denied. This is civil court. It's a lot more broad here. The judge will decide whether or not it's admissible, but pretty much everything is relevant in a case like this. Remember, the O'Keefes are suing Karen Reed, saying she created a false narrative that she was not involved with the murder of John O'Keefe and didn't hit him with her car, and that the other people were responsible in the death and or cover up. And so in order to disprove their false narrative, emotional distress claims, she's entitled to defend herself by showing or trying to show that the people in the house were responsible for it. And that is the relevance of Colin Albert's communications, because the time that he was picked up is in serious dispute, especially after the information came out in the most recent court, or one of the most recent court filings by Karen Reed's team, that the Life 360 data of Allie McCabe, which was downloaded and obtained through Jennifer McCabe's phone, shows that she was nowhere near 34 Fairview or Colin's house on January 29th of 2022. But now, all of a sudden, because of this aforementioned paranormal activity that I was telling you about, all the people on the other side are screaming, Life 360 is not accurate. And if she didn't stop there for 3 minutes, it wouldn't attract her there. Because, I mean, that's, again, I don't know what kind of paranormal activity happened that night, but maybe we can get some Ghostbusters in there and try to figure it out. Because the things that went on when you add them all together are just crazy, like some giant paranormal event, right?
Obviously, you don't have to decide what information and evidence may be admissible or not. That's not the issue. But the reason that inquiry about relevance exists and is important for the court to conduct is because otherwise parties would engage in fishing expeditions all the time, which I know this court doesn't want, we don't want, but which Ms. Reed seems to be seeking.
One example of something that would not be limited to the about circumstances of Mr. O'Keefe's death. There are allegations that Ms. Reed has made in multiple lawsuits, including this one, that certain of the individuals in the house deleted phones or deleted contents of phones or devices. That obviously happened well after Mr. O'Keefe's death. If there was a text, and I'm not saying it exists because we don't know if it does, but if there was a text between Mr. Albert and someone else who was in the house that said, get rid of your phone, that would be very, very, very relevant to the alleged false narrative claims and the conspiracy that Ms. Reed has alleged, and it would absolutely not be covered by the circumstances surrounding Mr. O'Keefe's death.
Ooh, I mean, I don't know. This is just a hypothesis, but what if Proctor said something to others involved in this case saying, get rid of your phones? Thank you, Aaron Rosenberg, for these little Easter eggs that you keep dropping. I don't know if that's true or not. That he's just using it as an example. But what if Michael Proctor said, hey, here's how to change your iPhone settings to make sure that everything in your phone deletes every 30 days, because he thought he did that to his own phone. And then when he had to turn it over for an extraction to the Norfolk County DA's office, they got all of his data going back to like 2012 or 2013 because he didn't do it right, or he wasn't so smart, or it's still in the cloud. But that's interesting. It's an interesting example, right?
There are plenty more, but I think that highlights the concern.
So they say it's included, you say it isn't.
Well, they say generally it's included, but if it were included, if the answer was
It's stated on the record in 2 areas that they're going to produce what you're looking for.
right, but as your honor is aware, it's not our job to give them the specific examples of documents that may exist in their client's possession, custody, or control. It's our obligation to give them a sufficiently limited amount that it doesn't impose an undue burden on them, but categories. And that's what we've given. They've taken those categories and significantly narrowed it. And I recognize that Mr. Maddie, and I believe Mr. Maddie, that the 2 examples that he's commented on today, he says would fall in their narrow, very narrow categories. And that's great. But I think there are tons of other things that would be very relevant that would fall well outside that. And I don't think that's proper.
Anything else?
Thank you.
Anything else?
Not on this. I just wanted to briefly update you about a different motion. Are you?
Hey, Buck, do you want to jump in? Or you
No, I'm sorry, just one other.
Stay seated.
I don't want to be well.
Maddie's not even a party in this case. He's not an attorney in this. He's not a plaintiff or a defendant. Buck, the guy sitting next to him, Mr. Buck, is Diller's firm. And I'm going to point out, just like watch for it, but I like Mr. Buck and his demeanor and his attitude and the way that he speaks to the court and the other attorneys in the room far more than I like Diller. So just pay attention for when Mr. Buck speaks and tell me if you agree. But Maddie jumps up in front and runs Buck here, where he's like, Mr. Buck, do you have anything to say?
Sorry, just one other.
Stay seated.
And
Wanted to briefly update you about a different motion. Are you?
Hey, Buck, do you want to jump in? Or you
No, I'm sorry, just one other.
Stay seated.
I don't want to
be well enough.
I don't want to steal Attorney Buck's thunder. There is the outstanding issue, Your Honor.
every time he says, I don't want to do something, he really does want to do it. I don't want to steal Attorney Buck's thunder. Yes, you do. I don't want to interrupt, or said something earlier. Yes, you do.
About Mr. Albert's availability for a deposition. I know we've started discussing the scope, and so I'm happy to discuss that whenever it makes sense for the court.
Go right ahead.
Okay. Your Honor, since last week, we have made inquiries of the United States Army at Fort Jackson, and we've also done some research about how a deposition of an active duty service member would be arranged. And bottom line up front, Mr. Albert, as a trainee in the United States Army, is under the command and control of his commanding officer. And so if Ms. Reed wishes to take his deposition, yes, sir.
Just curious, did your research include a subpoena that already was served?
Well, Your Honor, so I guess the question you're raising is.
Oh my God, that was total snark from Judge Gilday. He says he's doing research on how to contact him in the Army. He's like, does your research include the subpoena that was already served? As in, the guy went into the Army knowing that he was under subpoena to testify in this deposition. This is not news to him. He had a valid subpoena. They said they were going to reschedule the deposition, and he decided to go into the Army anyway. Like he made his own bed, basically. But listen to this.
Ms. Reed, online up front about how a deposition of an active duty service inquiries of the. Your Honor, since last week, we have made inquiries of the United States Army at Fort Jackson, and we've also done some research about how a deposition of an active duty.
He talks about research, and listen to what the judge claps back.
Service member would be arranged. And bottom line up front, Mr. Albert, as a trainee in the United States Army, is under the command and control of his commanding officer. And so if Ms. Reed wishes to take his deposition, yes, sir.
Just curious, did your research include a subpoena that already was served?
Well, Your Honor, so I guess the question you're raising is, if Mr. Albert had been served with a subpoena.
She had been.
Correct. Prior to entering the military.
He had been.
And let's presume for a second that subpoena remains valid, even though I know you know we take a different position. And he then enters the United States Army in the interim. The United States Army has custody of his person. And so if the deposition is going to take place after the date upon which it was originally scheduled, April 29th, I think, then the only way for that deposition to occur is with the consent of the United States Army. And there is a process for that. What would happen is Attorney Reed's counsel, Ms. Reed's counsel, or we could help facilitate this process, would reach out to the staff judge advocate at Fort Jackson and let them know that there is a request for a non-party in civil litigation pending in Massachusetts to take Mr. Albert's deposition. And I've never done that before, so I don't know exactly how that process would play out, but I know that that would be the necessary first step. Now, I've called the staff judge advocate 4 times at Fort Jackson between last week and this morning. I've left 4 messages. I haven't heard back. I've also consulted with a colleague who's a former JAG officer with 2 combat deployments. She advised me that the process would definitely include the staff judge advocate at Fort Jackson, may also include the Army Litigation Division, which is the main legal component of the United States Army. And that process would just have to play out. But the reality is neither we nor Mr. Albert have any authority to present him for a deposition while he is in basic training. He's not given any leave. He's not given any visitation at Fort Jackson. He has very limited access to telephone. His day starts at 4:30 in the morning, ends at 9 p.m., and it's entirely structured.
His day starts at 4:30 in the morning and it ends at 9 p.m. and it's entirely structured and he doesn't even have a phone. Okay, so there go all your arguments about anybody harassing Colin Albert over social media during the time that he has no access to his phone, because if he didn't see it, is it harassment? This is where he starts getting into, here's my tiny violin. Poor Colin, poor Colin, poor Colin. Listen, okay? I've been a civil litigator for well over 30 years. My entire career was in civil litigation, plaintiff's work, okay? Depositions are rescheduled all the time, okay? The reason they agreed to reschedule this deposition is because Colin Albert's attorneys didn't want to turn over all of the communications that Karen Reed's attorneys requested from him so that they could properly depose him. If they didn't have anything, they could have said, we don't have anything, but they didn't. They kept objecting to the scope of their requests. And so they went back and forth and back and forth. And Karen Reed's attorney said, okay, let's give him some more time to keep looking. Let's narrow down the parameters of the things that we want. And when we can agree on the parameters, you tell us what you have or that you don't have it. And then we'll go ahead with the deposition. But that's not what they did. They're just arguing now that because the deposition was adjourned due to his failure to not turn over the documents or even respond saying he doesn't have anything, that now the subpoena is invalid. That's not how it works, okay? Attorneys reschedule depositions all the time. And as a plaintiff's attorney, Mr. Maddie, you know that. To come in and argue that the subpoena is invalid because that deposition was rescheduled is disingenuous. And yes, Teresa, I agree with you. This judge has impeccable comedic timing. There we go.
And the basic combat training program is phased, so that phase 2 builds on phase 1, phase 3 builds on phase 2. This is a 10-week program, after which we understand he will be granted leave. And so what I asked counsel last week was, listen, if Judge Gilday were to permit, given the burden that forcing Mr. Albert to submit to a deposition while he's in basic training would impose, if Judge Gilday were to permit an enlargement of the scheduling,
the burden on Colin Albert. Listen to this. Sir, what part of this hard stop discovery deadline do you not understand? And I point out to you again, he is a plaintiff's lawyer. This is what he does for a living, but right now he's acting as a defense lawyer in the case where, well, Karen Reed didn't sue Colin, so he's now just acting as the non-party lawyer. But he also represents Colin Albert as a plaintiff in the defamation case. So listen to as he talks about the burden on everyone. It'd be too burdensome to get him here for a deposition. And I think that he really thinks that he's going to win this argument and that the judge is just going to say, okay, that's okay. Colin doesn't have to come until he's back from the Army. Conrad Birdie.
which we understand he will be granted leave. And so what I asked counsel last week was, listen, if Judge Gilday were to permit, given the burden that forcing Mr. Albert to submit to a deposition while he's in basic training would impose, if Judge Gilday were to permit an enlargement of the scheduling order for the sole purpose of conducting this deposition after Mr. Albert completes basic training, and if the other defendants, if the other parties agreed to that, would you? And they said no. And I asked them why, and they said they had strategic reasons. And what it made me wonder is why they hadn't taken his deposition in the many, many months during which this case has been pending, and why they didn't take his deposition when he actually sat for it 2 weeks ago.
We just told you why, because he didn't prove the information. And Mark Diller, deciding that he's going to depose him on one of 2 days when Chaz Waters, who was going to do the deposition for Karen Reed's team, was out of town. The burden on Colin Albert. He was subjected to a subpoena before he even decided to enlist in the Army. So enough already with the red, white, and blue. Okay, this is all BS. It's gaslighting. And he knew when he enlisted that he was going to have to give a deposition. So enough already.
Ago.
Well, the answer to the latter question is they didn't have the documents, and they had said in their discussions with you that they wanted the documents before they took the deposition.
And they don't
Bingo.
have the documents now, Judge. And so what I'm saying is, given the burden that this would place on Mr. Albert, and the fact that he's already been,
Excuse me for interrupting, but the burden is self-imposed. Because
The burden is self-imposed. I'm sorry, I forgot to turn the closed captions on because we know the judge always sounds like he's talking into a tin can with a string because he doesn't, I don't know where his microphone is, but he speaks loud enough, I guess, in the regular courtroom that he probably doesn't even need it. He's trying to play the military card. Yep. And here he's going to say, excuse me for interrupting. Again, he doesn't really, he means to interrupt. Given the burden that this would place on Mr. Albert, and the judge says this is a self-imposed burden. Okay, listen again. Self-imposed for the win. His communique timing is impeccable.
burden that this would place on the judge. And so what I'm saying is, given the burden that this would place on Mr. Albert, and the fact that he's already,
excuse me for interrupting, but the burden is self-imposed because there was a subpoena. And as I've said a number of times, a subpoena has to mean something. And there was also some agreement between the attorneys. And the words and actions of an attorney need to mean something too.
Your Honor, let me just say a couple things in response. First of all, I am not aware of any agreement between attorneys. I've read that email traffic. I was not the one negotiating this, but I've read that email traffic. And that deposition was canceled. And if they want to take a deposition of him on a different date, they can issue a subpoena for a different date. But it is my understanding that there was no agreement. I also want to just say one thing in response to the idea that Mr. Albert has imposed a burden on himself. If he is told that his deposition is being canceled, and then he alerts everybody to the fact that he's decided to enlist in the United States Army to serve his country, and tells everybody that he's going to
God bless America. Should we get up and salute and start the we love you, Conrad. Oh yes, we do. He's doing it for America, everyone. He's doing it for America. This is a man who is scared of a turtle, and he's going to go defend his country. Listen to now, here comes there should be some music playing behind him. It wasn't canceled. It was rescheduled. There's a difference. They didn't withdraw their subpoena and say, you know what? We don't want his deposition at all. He's free to go. They didn't do that. Stop it. You're making a fool out of yourself. Everyone thinks this guy, everyone who thinks John O'Keefe was hit by a car, and the forensic ladies and all those people who are, probably being paid by the Alberts to come out and spin their narrative that they're assigned every morning, think that he's savage. He's a savage. He's the greatest thing since sliced bread. They're not going to know what hit him. He's being disingenuous to the court because he is, in fact, a plaintiff's lawyer. Okay? Okay? Did you ever withdraw a subpoena? Did you ever cancel a subpoena and instead of rescheduling because there was a conflict or somebody had something else to do that day and couldn't make it, the guy was sick? Did you just assume that you had to serve him again? No. Stop it. Stop it. You're embarrassing yourself.
idea that Mr. Albert has imposed a burden on himself. If he is told that his deposition is being canceled, and then he alerts everybody to the fact that he's decided to enlist in the United States Army to serve his country, and tells everybody that he's going to be available for a deposition in a compressed period of time, and one party decides not to take advantage of that, and then he enlists and subjects himself to basic training, and the idea is that he was supposed to organize his life choices as a non-party witness around when Miss Reed might ultimately decide to take his deposition.
He's subjecting himself to basic training. He's subjecting himself to basic training. What do you mean? He's subjecting himself. So he really want to do it? He's subjecting himself to basic training? Is it like subjecting yourself to the police academy where Enrique Delgado Garcia was killed? Is it like that? Listen to that again. His choice of words. Lawyers choose their words very carefully, very carefully. And I always say, I remind you that what they don't say is often almost as important as what they do say. But he wants us to believe that Colin Albert is subjecting himself to basic training. And then his life choices should revolve around when Karen Reed chooses to depose him. Sir, take all the seats.
And subjects himself to basic training. And the idea is that he was supposed to organize his life choices as a non-party witness around when Miss Reed might ultimately decide to take his deposition. I don't think it's fair to suggest that he's imposed this burden on himself. He's undertaking a burden to serve our country, made himself available for a deposition. And now all we're saying is, under these circumstances, wouldn't it make sense to conduct this particular deposition when the young man has completed his basic training and after which we've resolved all these issues about documents?
Wow. I mean, that was some speech. Wasn't that so patriotic? That was so patriotic. Like his life choices, because his life choices up to this point might not have been so good. Bang, bang. Bang, bang.
Deposition wasn't canceled, Your Honor. You can read the emails yourself. I'm the one who wrote it. Said the deposition will be rescheduled when we resolve the pending dispute over the documents. Mr. Maddie points out we still don't have the documents. That's because they still haven't agreed to produce the documents, and we need to be back here with Your Honor for a second hearing to get what we believe is a significantly narrowed scope, which we proposed last week after Your Honor provided some feedback on the initial scope. Also, subpoena is not a request. Mr. Maddie said a request that he be deposed. It's not a request. It's a court order. The case law is clear. A subpoena is a court order. And obviously, we're not looking, as I've said, to impose an unfair burden. We recognize that the service didn't happen in time and immediately said, yeah, that's too tight. We will reschedule it. To now argue that by saying we will reschedule it, which is exactly what the email says, that we canceled the deposition and rendered the subpoena ineffective is, I think, absurd. And it flies in the face of the obligation that a party serving a subpoena has, as Your Honor pointed out, to work with the recipient in order to do it in an efficient way and not impose an undue burden. I also haven't heard any of this until right now. We've been conferring. I heard that it's difficult, but the specifics of the steps that they've been trying to take, we haven't heard. I would have a couple questions. One, was Mr. Albert asked to identify this proceeding and the subpoena that he had received when he enlisted in the military? If he was, does that impact his ability to come back to Massachusetts to appear pursuant to the subpoena that was issued in this case? Mm-hmm. At the end of the day, everyone here, I think, respects a decision to serve our country, but the timing of this is extremely relevant. We served the deposition, the subpoena. We had the back and forth where we said we would reschedule. We waited 3 weeks for a response on the documents. We got an email that said, in effect, he's available for the next 13 days and then he's gone. That's not appropriate, and that's not in compliance with a subpoena that's issued by counsel through this court. And if there's something we need to do in order to make it more possible, I'm more than willing to hear what we can do to help do that, but there's been no proposals, just he can't do that. And to address briefly this idea of extending the scheduling order, as Your Honor is aware, we've been working over the course of many months now with the understanding from Your Honor that that is a hard deadline and we need to do everything we can to get everything done in that deadline. And we've made tons of decisions in reliance on that, and you've effectively kept us to that. We've got depositions, many this week that we're taking. Plaintiffs have taken a number. Things are moving forward. It'd be completely unfair for us to now have the deposition that we noticed early on in the schedule be put way back, in fact, after the deadline that we've all been operating under.
Your Honor, I don't understand any prejudice to Ms. Reed or her counsel for taking this deposition 3 weeks after the August 17th deadline. I'm not understanding what the prejudice might be. I do understand and respect the need for court order deadlines. Here,
I don't know what their strategy is. I don't know either.
that being said, whatever their strategy was, apparently meant that they weren't going to take his deposition in the first year in which this case was pending, and then decided that they would take it. And then when there was a dispute about documents, Our position is they can't put, our position is that there is not a valid subpoena to be enforced right now. However, given the importance of working collaboratively with counsel, we are going to continue to do that. And if the court tells us that we need to find a way to pull Colin Albert out of basic training, we will go ahead and see what that process is and pursue it. But I don't think that's fair to him. I really don't. And
I don't think that's fair to him. He's being subjected to basic training. Serving our country is a privilege, not a burden, sir. And you don't think it's fair to him to have to leave basic training when he knew that he was under subpoena and that he was going to have to appear for a deposition? I mean, tell me what you think, but does this make it seem a little bit more sus? And like the judge said, it's the timing of it. It's the timing of it. This argument just makes him look like he's got something to hide, and you shouldn't be doing that to your client. And that is why this man should not be representing all of these people. You should not be representing Colin Albert and Jennifer McCabe and Brian Albert, because they all have very different interests here. And that's going to become apparent. And I hope all these clients signed off on this conflict, because if somebody raises the conflict, you can't represent any of them. It's like Conflicts 101. Remember, he represents in the defamation case Jennifer McCabe, Brian Albert, Colin Albert, and Brian Higgins. 4 people whose interests could not be any more different. None of them are related to each other as far as like husband, wife, or parent, child, which may make more sense if he represented, let's say, Jen McCabe and Matt McCabe, just for an example, or, Chris Albert and Colin Albert, but he doesn't. Listen to how he's talking about how it's not fair to Colin to pull him out of, you just said it was a burden. You just said basic training was a burden. So if we alleviate a little bit of his burden by giving him a day or 2 off to fly back from South Carolina, he's not halfway across the world. He's in South Carolina. For Christ's sakes. If the court tells us that we need to find a way to pull him out, he told you that last week. He told your co-counsel that last week. He told Tuxbury, figure out when you can get him here. Okay. So now you're saying if the court tells us we need to find a way, I'll make more than 4 phone calls and leave more than 4 voicemails and really try and get him here. But that's what the court said last week. He said that's not happening when they told him he couldn't come until the fall. He said the deadline is August 17th. And Tuxbury said, oh, well, he's not going to be done until the fall. And Judge Gilday said, and I quote, that's not happening. So which part of that sentence did you not understand, Mr. Maddie? I mean, I know you weren't there last week, but I'm sure that you went on the internet and you watched the hearing, or at least your co-counsel, Jimbo Tuxbury, reported back to you that the assignment was to find out when you could get him here before August 17th. It's really not rocket science. It's really not. But let's hear some more about why it's not fair to Colin Albert. And then we have the little tiny violin here.
Going to continue to do that. And if the court tells us that we need to find a way to pull Colin Albert out of basic training, we will go ahead and see what that process is and pursue it. But I don't think that's fair to him. I really don't. And I don't think Attorney Rosenberg thinks that's fair to him. When we could take this deposition just a few weeks after, 1 witness, then he will have finished basic combat training. He will be on leave. You won't need to go through this process, which I'm just now learning about trying to persuade.
You won't need to go through it. The judge doesn't need to go through it. You need to go through it. Don't talk to the judge like it's his problem. It's not his problem. It sounds like a you problem is what it sounds like. This is your client, okay? You should have advised him that maybe enlisting in the Army right now is not a great idea since he's under subpoena. You should have advised him properly, okay? You shouldn't have told him that his deposition was canceled, because we all know it wasn't canceled, okay? We read the emails. It was going to be rescheduled to a more convenient time when he could get his act together and produce the documents. Or you could tell them you didn't have any of the communications, that they don't exist, okay? So the judge doesn't need to go through any process. It sounds like a you problem.
1 witness, then he will have finished basic combat training. He will be on leave. You won't need to go through this process, which I'm just now learning about trying to persuade the United States Army that they should release a witness for a civil proceeding in Massachusetts when they don't even let him have his phone. However, if that's the course of action that the court wants us to take, we will work with Attorney Rosenberg to try to facilitate that. I just think it's highly unfair to this young man.
To be clear,
I just think it's highly unfair to this young man. You know what's unfair? Being tried twice for a car accident, murder that didn't happen. That's unfair. Okay. Okay. You want to talk about unfair? Come on, dude, read the room. Read the room.
The court wants us to take, we will work with Attorney Rosenberg to try to facilitate that. I just think it's highly unfair to this young man.
to be clear, I do think I understand the burden it imposes, but as Your Honor said, it's a self-imposed burden that he knew he had this subpoena. He decided to enlist when he decided to enlist, and that resulted in him being unavailable less than 2 weeks after he could give the other side notice. So this is not someone who was already enlisted, who we tried to serve a subpoena or say served a subpoena when someone was back on leave, and then they ended up back under the control of the military. That's not what happened here. The timing is set out very clearly in the communications that are part of the record. And I think not only is it fair under the circumstances, I think it's required. And I would ask the court to order Mr. Albert's counsel to present him. And I represent to you that we will work with them and do what we need to do to assist that.
Well, first of all, he was available for a deposition. He was. He sat for a deposition in this case. And secondly, Judge, in all deference, if you order us to make efforts to arrange his appearance at a deposition, we will do that. But we do not have authority to produce him on our own. The United States military does.
I think it would be a great idea if you found out more.
We'll continue to work on that. I was hoping they would take.
He told them last week to come in today with dates. Okay. What part of that didn't you understand? He's whining. I was hoping they would take my calls, but they didn't. But we'll continue to try. We're trying really, 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 really hard. Here's Colin Albert's heartbeat right now. Judge is like, yeah, you should. Don't come back to me until you have the information. I told you to get the information last week. He's being actually rather nice about it. There's some judges that really would have snapped at him and said, what part of my ruling last week did you not understand when I told you to come in today with dates?
He was. He sat for a deposition in this case. And for to do to assist that. Well, first of all, he was available for a deposition. He was. He sat for a deposition. He doesn't get to pick his deposition date, okay? He doesn't get to say, oh, here's the only time I can do it, so let's do it. And then the only people that show up are Diller and one of the bars, and the other bar is on Zoom and doesn't ask any questions. And Karen Reed's attorneys aren't even there because I don't care if they were in the same building. They don't have the proper documents to depose him. It's not how it works, sir. And you know that. You know that. Take all the seats. For a deposition in this case. And secondly, Judge, in all deference, if you order us to make efforts to arrange his appearance at a deposition, we will do that. But we do not have authority to produce him on our own. The United States military does.
I think it would be a great idea if you found out more.
We'll continue to work on that. I was hoping they would take my calls. They didn't. But we will continue to work to find out more about how that process might play out. I think I'm confident that the initial step would be reaching the staff judge advocate and informing them person to person of the status of the situation. I've left that information in my messages, but I haven't been able to reach anybody. And I will continue to do that if that's the court's recommendation.
You might not want to.
Don't you know who they are? Don't you know who they are? Don't you know who he is? Here's the little duck. This is how ridiculous this whole thing is. If the court orders us, a subpoena is a court order. Hello. Listen to the next thing the judge says, because this is the most important thing he says during the hearing.
I will continue to do that if that's the court's recommendation.
You might not want to use the words, the other side canceled the deposition. Maybe couch it in terms that it's disputed.
It is disputed, and that's
You might not want to use the words that the other side canceled the deposition. We've seen the emails. It was rescheduled. And if you told your client that it was canceled, that's on you. He says you might want to say it was disputed.
Couch it in terms that it's disputed.
It is disputed, and that's our position. Thank you, Judge.
Thank you.
Your Honor, can I briefly just update you on that other motion I was talking about? It wasn't that. You asked at the end of the last hearing what other motions were coming to you. There's one that relates to Mr. Madwell. I think Mr. Maddy's representing them, but the other individuals.
He's not jumping up.
Yeah, I know. I don't want to. Well, he's representing some of them in the defamation case.
Yeah, I don't want
to hesitate.
I don't want to take too many liberties with the court's involvement.
I was trying to be careful, but we've got deposition notices and a motion to compel for Brian Higgins. Not Brian Higgins. Brian Albert, Nicole Albert, Jennifer McCabe, Matt McCabe. That's coming to you very shortly. We discussed that earlier.
Oh, so it looks like Brian Albert, Nicole Albert, Jennifer McCabe, and Matt McCabe also don't want to come for their depositions because remember, in another hearing, we heard Mr. Rosenberg say that they were told that they're not going to be available until like July or August, and they can't possibly be deposed before then. So what's he doing? He's got to make a motion. He's got to make a motion to compel them too. Brian Albert, Nicole Albert, Matt McCabe, and Jen McCabe. And Allie? Did you say Aunt Allie too? Hold on.
Not Brian Higgins. Brian Albert, Nicole Albert, Jennifer McCabe, Matt McCabe. That's coming to you very shortly. We discussed that earlier. Separately, we had a deposition scheduled of Lieutenant Brian Tully of the Mass State Police. We served Lieutenant Tully with a subpoena May 5th, and it sought documents June 1st and June 11th. So we did a better job with the service. His counsel asked to reschedule for July 8th. We rescheduled. And then the day after our hearing last week here, we got a motion to quash asking the court to say he doesn't have to show up at all, doesn't have to produce any documents. Came out of the blue.
Brian Tully does not want to testify at all. A motion to quash the subpoena means, Judge, we're going to ask you to quash, to release him from the subpoena. Look at the judge's face. He is not happy. My freeze game is so on point today. Look at the judge. Really? Oh, now Tully's trying to get out of his deposition too? Why would he do that the day after the last hearing last week? Why would he do that? He wants a motion to quash. Now, here's why we don't have the papers. Because in Massachusetts, they have this weird thing where you don't file the motion with the court right away. You serve the motion on the other side. So Tully's attorneys would have served everyone, in this case, with the motion to quash, and then they all have to respond to it. And then once the package is complete, Tully's attorneys have to file it with the court after the opposition is in. Rosenberg is going to go on to say that they opposed that motion immediately the same day, last Thursday, and that as of right now, it is still not filed with the court. But the judge does not look happy about that. You can run, but you can't hide. Same goes for the motions to compel Nicole Albert, Brian Albert, Matt McCabe, and Jen McCabe. If they haven't responded yet, once they respond, then the person who made the motion, the movant, in this case, Karen Reed's team, is making the motion to compel those people. Once they reply, then it gets filed with the court. Let's go back and look at the judge's face as it morphs.
His counsel asked to reschedule for July 8th. We rescheduled. And then the day after our hearing last week here, we got a motion to quash asking the court to say he doesn't have to show up at all, doesn't have to produce any documents. Came out of the blue. They didn't confer with us. We don't know why there would be a change when we accommodated the date. So that we served an opposition to that motion the same day we got it, which was last Thursday. And we urged them to please file it with this court as soon as we can. I don't believe that's happened based on the docket, but I just wanted to give you a heads up that is on its way.
He's not happy.
4 parties should talk about. There's a motion ready to be filed?
Yeah, I believe the opposition is due today.
It's my understanding that we'll be serving our opposition, or that those individuals to whom the motion is directed will be serving their opposition today, I believe.
Okay, so this was yesterday. So he's now speaking for the other Haas defendants, Jen McCabe, Matt McCabe, Brian Albert, and Nicole Albert, but he wants to be very careful and tiptoe around this issue because once again, he has not been admitted pro hoc vice into this case because co-counsel Tuxbury told the court and the world that it's very expensive to do so, and they don't want to spend the $350 to have him admitted pro. It's literally the signing of a paper, the filing of a paper, the paying of the fee, and the judge signing off on it. Remember how easily he pro hoc'd in a whole bunch of other people, including Betterow. They don't want to pay the money. They might want to pay the money because it seems like maybe Tuxbury is not going to be available if he's on these long vacations. It's wild.
And
But now he tells us that he is representing those other four, and so he's going to file the opposition. He says he filed it yesterday.
we'll aim to file it tomorrow.
I do represent a number of them in the defamation case, Your Honor. It's the same situation as we have with Mr. Albert here. I'm not admitted to represent them as witnesses here.
You're probably going to be here on their behalf.
Well, if Mr. Tuxbury is still on vacation, I probably will be, yeah. With your permission, of course.
When would
File
you
the
like to
papers.
do that?
Before we jump to that, the plaintiffs have two forthcoming motions that, contrary to, public belief, I have other cases that have depositions too. Personally, I don't, just for the record, to be clear, I don't want to convince the U.S. Army of anything. But the plaintiffs have forthcoming motions to compel Aiden and Kearney, as well as further answers to interrogatories from Miss Reed.
Okay, it's Carney. Can we all just say it together now? It's Carney. I mean, I like this guy so much more than I like Diller. He seems like a really nice, reasonable man. He's like, Your Honor, I just want to make it clear. I don't want to force the Army to do anything. This is not my fight. I don't want to force the Army to do anything. But I do have a motion to compel Aiden Carney, I guess, for what? I'm not sure. But also to compel Karen Reed to supplement her interrogatories. We will look for those as well.
I believe the opposition was just served the end of last week. I've been out of the office Friday and today, so I believe that both will be filed either tomorrow or Wednesday.
When would you like to do those?
I assume we're going to have four now. I think we're going to have those two. We're going to have ours as soon as Lieutenant Tully's counsel files his 9A package, and then our motion. So I'd say as soon as we can, because.
Or I was going to suggest right after the 4th of July holiday, possibly. We have a robust deposition calendar, as Your Honor's aware.
I don't know the court schedule. We could do July 2nd to get it because Lieutenant Tully's deposition is supposed to be the 8th. We've got that set aside. Everyone has that set aside, I think.
I believe we're scheduled for a 30v6 on the 2nd.
I think that's the one that you just emailed and said they asked.
We were double booked that day.
Okay.
So there's 30v6 of CF McCarthy's.
How about the 6th? It's the Monday after. I don't think we have a depot.
Maybe check with the court and see what was good for them. You guys are just, like the judge doesn't know what the case is.
Currently scheduled for the 6th.
This is my only case, so don't worry about it.
See?
Just like all of us here on.
They look like counseling.
It looks like we just have one thing on the afternoon.
Say it again. We don't have a trial that day. Okay. So why don't we say 2:00 on the 6th?
Would that be for the first motion Attorney Rosenberg described as well?
Whatever you got,
Altogether.
whatever you got out there, let's get it
Yeah.
in here. And
Okay, all right.
Yeah, we'll file it as soon as.
What I'd like to do, Judge, if you don't mind, if we could tentatively set that as the date, and then I could consult with co-counsel and just make sure that works for them. And if for some reason there's an issue, I could confer with Attorney Rosenberg and everybody else. Would that be all right?
We were seeing the sidebar for a second. Sure.
Oh my God, just pay the $350.
Okay, so this matter is continued to July 6, 2026 at 2 p.m. for the motion hearing.
Still have our status on
Friday.
Friday at 9:45.
At your honor's direction, the World Cup fan inside of me put that aside and worked through the weekend to update the court on the pending motion to compel documents from Ms. Reed. Would you like to hear that? Go ahead. So,
The World Cup fan in me worked all weekend. He's kind of funny. His jokes aren't really landing. Nobody's laughing, but I think he's trying to be funny.
for our conversation last week, there was a link sent to me while Attorney Fell and I were conducting a deposition prior to the hearing here on Wednesday, the 17th. Over the weekend, I was able to access that link and confirm that there were responsive documents included. The plaintiffs have some concerns to date. We have submitted 53 requests for documents to Ms. Reed. 34 of those were met with objections for attorney-client privilege and work product. I do not have any privilege logs to date, nor do I have what I believe to be compliance with Superior Court Rule 30A that states the documents that are being withheld due to that specific objection. That being said, Ms. Reed is scheduled to offer deposition testimony on Wednesday of this week, less than 48 hours from now. The first testimony she's given to date. And my clients are at an extreme disadvantage because I anticipate forthcoming motion practice as to those objections, but without knowing what's withheld, I can't pursue the additional motion practice to put in front of this court to determine whether or not that privilege upholds.
So if I'm reading between the lines here, are you saying that Karen Reed's deposition that's supposed to take place tomorrow is going to be rescheduled by you because of the objections to your interrogatories? Why not just ask her those questions under oath if you're going to be able to get her in a room? Everyone's always squawking that Karen's been, too afraid to appear for her deposition, which is wild because she's also a plaintiff in another lawsuit. But are you saying that you're not going to go ahead with her deposition tomorrow because of these objections? This was yesterday, but it sounds like foreshadowing to me.
This issue, Mr. Buck and I discussed right for the first time at the beginning of the last hearing last week on Thursday. As I told Mr. Buck, we agree we're going to get them the information that's required by Rule 30A. We're working on it right now. We were already working on it when Mr. Buck asked me first on Thursday, and we will get it to them. This is the first time hearing of an issue tied to the upcoming deposition. I will talk to the people that are doing it right now and try to get that to them before that deposition. But they have, obviously, they'll decide how to handle that at their deposition.
Maybe remind them that if you're going to make such an objection, you're supposed to provide the privilege log, not something you work on after you make the objection.
Well, we identified the objection, and then once we've withheld the documents in the production that just completed, we are providing the information, but
I know
it's taken.
This is not the collective view because you get someone else you got to consult with, but they obviously had the documents in front of them in order for them to make the objection, right? So the next logical step would have been, let's give them a privilege log.
Well, not necessarily in front of them when they made the objection, because the objection is made in the written responses. You're not looking at the documents at the same time. But I understand, Your Honor. We're not fighting that.
We did have a conversation about it, but to Your Honor's point, the initial responses to my first request were served on me in October. I don't have a privilege log for that request either.
Yeah, Attorney Rosenberg, it's similar to the last discussion on the motion to compel. You collectively suggested the issue was moot because you had filed a written response, but you hadn't produced the documents. I know you've taken care of that, but all that just engenders delay.
I agree, but I would say the reason that those keep coming before you is, like right now, we haven't had a conversation yet under Rule 9C about the timing of when we're going to give them the privilege log. It was raised for the first time at the beginning of last Thursday's hearing, and my response was, "You're right. We're working on it. We're going to get it to you." This is supposed to happen, frankly, outside of the court. This is supposed to say, we need it by Tuesday because their deposition is out on Wednesday, and let me respond.
But I think what Attorney Buck is saying is we should have got it a long time ago.
And I'm by no means here claiming nefarious action or anything of the sort. I'm stating facts because Superior Court Rule 30A states that where a privilege log is required, the log shall be served with the supplemental response unless the requesting party waives entitlement to the log or agrees to a later date for service.
I'm not suggesting nefarious.
Well, I mean, look at Attorney Buck standing up and not accusing the defense of nefarious actions, as Mark Diller often does, right? Privilege log is if you're going to claim that you're not turning over certain documents or communications because you're claiming that they're privileged by attorney-client privilege or something else, you are required under the Massachusetts Rules of Civil Procedure with your response to include a log of what it is that you're claiming is privileged, when it was written, who received it, generally what it's about, and you have to delineate each thing that you're withholding and what the privilege is. And so even Buck is like, I don't think they're doing anything nefarious here. And the judge says, I'm not saying they're doing anything nefarious either. But the judge said, if you're claiming all of this stuff is privileged, of course you looked at it, right? Why didn't you just provide the privilege log then? And he's got a point. Fire pilot's wife gives you 20 memberships. 20 memberships. You're a very sweet, sweet pea. Thank you for being such a sweet pea. And to all those who were randomly gifted by YouTube, enjoy your member emojis. We have many, many that were created, especially curated for the Karen Reed trial. Let's keep going.
Or agrees to a later date for service.
I'm not suggesting nefarious actions by anyone. I'm just suggesting actions that result in delays. More need to come in front of me and talk about this stuff.
I understand that, Your Honor. I'm just saying, I think we didn't need to come before you to talk about it, frankly. And the supplemental response is the supplemental written response in Rule 30A, which comes after the documents are produced. So I really don't think this is something we need to quibble with before Your Honor. We will get it to them as quickly as we can. And if we can do it before Wednesday's deposition, we will do that.
Probably not going to complete the deposition in a day anyways.
I don't anticipate that the likelihood of that is very high.
Certainly with other parties too.
Yeah. I just wanted to confirm that you had requested that I review the link, and I've done that. And as we said here, my preliminary review shows that I received responsive documents to 3 of my 16 requests. So I anticipate further motion practice and at a later date. But you requested that I look at everything in a day.
All right. We'll see everyone on Zoom on Friday morning at 9:45.
Looking forward to it.
Not me, Your Honor, right?
We'll admit you if you want.
Not yet.
Thank you.
Thank you.
Thank you, Your Honor.
Thank you, everyone.
All right.
Okay. Shout out. Camera pool footage supplied by WFXT TV. And this was, I think, the feed from Canton Community Television, who posted this late last night, and I played the trial channel version of this coverage. So shout out to all of them. Shout out to all of them. You guys are really going crazy in the comments. So let's take a look and see what it is that you have to say. Not as exciting as I'm sure many of you would like it to be, but once again, he got out of Dodge. He got out of Dodge. People think it was to dodge the deposition, but, you know, do you think, as Chris Maddie said, that his life choices should revolve around when Karen Reed wants to depose him? Josie Lou said choices we make equal consequences we face. C'est la vie. Thanks, Josie Lou, for your 20. Overruled. Sit down. Says, if this was my kid and he had nothing to hide, I would let them have it all. They're squabbling about what they should get and what the search terms are, and they're going to have to come back on July 6th, 2 p.m. They're going to have a motion hearing that too will be in person. Thank you, Angela Sanders Books for gifting 5 memberships. You're amazing. I have some of Aiden Carney's papers. I'll pull those up after we go through these questions and super chats. Thanks for gifting 5 memberships. You're amazing. Y'all ain't right. Says, just remember, they would have happily framed Lucky for this instead of Karen. Thank you so much for your opinions and your 5. I appreciate you so much. A lot of people think that. Paula gifted a membership. Thank you, Paula. Classy Cupcakes. Thank you for testing. Test. Thanks for your deuce. Virtual Juror. Thanks for your super chat. Last week, Tuxbury said he's at a 3-week school. Yes. Maddie said he's at Maddie said he's at basic. The 2 cannot happen at the same time, which is that this is all wrong. Well, if he went on the 1st of June and 21 days is 3 weeks, and then he went straight from there to basic, it is possible. So I'm not going to say that that's a lie, but thank you for your 5. Elle says, you went over Colin's testimony a little while back, and your opinion was he wasn't directly involved in John's death. After recent events, has that changed? I think he knows more than he testified to. And so obviously I wasn't there. I don't know what happened. It could have been an accident. Is he the weak link? Is he the weak link? And that is why nobody wants to produce him for a deposition, because they don't know if he can stick to the timeline, right? I don't think he left there at 12:10. Was he a witness to something? May have been a tragic accident that they had to figure out what to do, and people saw it. I don't know. So I just don't know. Thanks for your 5. Deborah says, Colin's attorney talking about a deposition being canceled, not rescheduled, is very reminiscent of Ross telling Rachel, we were on a break. We were on a break. LS says, looking to get on the McCabe and Albert's payroll. I'm qualified to troll on the internet every day and say crazy stuff. Mama needs a side job. That's very funny. Just kidding. Everything is fine over here. So serving your country is a privilege, not a burden. Right? If you think basic training is a burden, then maybe you're just not cut out for the job of being in the Army. I don't know. I'm just saying. Bethany says ham sandwich, HAM, Higgins, Albert, McCabe. People are trying to, or some people are using that as their, like, their collective name. I just can't get on board with the ham. Mark says if they can't go to Fort Jackson and depose him there, he can come back to Massachusetts and do it and then restart his training. Thank you, Mark. I don't know if that is anything that is possible, but I do thank you for your super chat. Gen XIM says Karen Reed wants his deposition to impeach others' depositions. Right. And they have a strategy and they're entitled to their strategy. They're certainly entitled to, do the depositions in the order that they want to do them in. Right? And the judge is not going to stand for it. He's not going to allow it to happen after August 18th, August 17th. He's been very clear about that. I'm not sure which part of that Colin Albert's attorneys don't understand. Kate Strong says, is there a way to contact the attorney general at Fort Jackson and let them know that Albert's making fools of them and a recruit is under a subpoena? I'm sure there's a way to contact him. And he says he's trying to figure out how. And he left 4 voicemail messages, K Strong. What do you expect the guy to do? Try harder? Terry Raven is here from Ireland. Slancha says, I'm more convinced now than ever that Colin was involved in John O'Keefe's demise. I was kind of reluctant before, but now it's evident to me. Or maybe he's the weak link and they're afraid that he's going to slip up. I don't know. Don't know. Nick says if they make him come back, he probably won't come back. He'll realize it's actually hard and can't live without his phone. Thank you, Nick Indy, for your 5. Yellow Lead Bedero says, poor Whittle Colin with no phone or beverages. Wild how his lawyer thinks the law does not apply to him or his client. Kyle, thank you. Have you seen the about the Form 86, Standard Form 86 for national security? That question specifically about pending lawsuits. Did Colin lie? I don't know. I didn't see the form. Can't opine on whether he lied or not. I have no idea. I haven't seen his filled out form. Are you talking about a blank form? I don't know. Jules Juggs says the Army decides if Colin shows per federal law, not the judge. Thank you, Julie. Love always. Elizabeth says, thanks, Melanie, for the much needed, deserved, and Haas earned snark. Crazy how much these folks want to hide from the light at all costs. Thanks for your thoughts, Elizabeth. Jill, not Wendy, says, should we start a GoFundMe for the Pro Hoc Vice? I don't know. Maybe they can use some of the fundraiser money, some of the money they raised at their Juneteenth gala to pay the 350. I think there was a speech given by Mafia Masshole, and she said that all the money from the fundraiser was going to go to the defense fund for the Haas defendants. So I think they raised more than $350. Julie says, Mel, SCRH, Trump's Guild Day, subpoena, you should research. Okay, great. Thank you for the homework assignment. I'll get right on that. Thank you so much. I still have to pack my bags so that I can get on a flight to London, but I will get right on that. Thank you, though. I'll write it down. SCR, I'm joking, right? Thank you. Music to My Soul says, I'm concerned that if Colin's attorneys describe the subpoena as having been canceled when Colin enlisted, then it could affect the Army's response. Don't be concerned. Do you have grave concerns, Music to My Soul? Are they grave? Are they grave? Don't be concerned. Don't worry. You guys, worry is a wasted emotion. Most of the stuff that you're worried about is stuff that already happened. You can't change it. And half the stuff 90% of the stuff that you're worried about in the future may never happen. Worry is a wasted emotion. Concern is different. I understand, but I'm just going to throw out some pearls of wisdom to you. Because remember, today's badass affirmation, I'm getting better and better every effing day. That's your affirmation. Dear Dad says, I really want to know how people find Gilday's attitude. Is he biased against Karen? First of all, thank you so much for using the correct tense of bias, which is biased, B-I-A-S-E-D. If you're talking about somebody being biased, you're talking about them being biased, not biased, B-I-A-S. A lot of people don't know that. It's biased, but no, I don't think he's biased against Karen. I think he seems to be very fair and measured. And he just wants everybody to just do what they're supposed to do. Is it really that hard? Just do what you're supposed to. Do what you're supposed to, and then there's not going to be any trouble. I don't think he's biased at all. Love Me Some You says, I was rewatching The Real Housewives of Beverly Hills and realized you remind me of Eileen Davidson. Oh, thank you. I don't know who that is, but I'll look it up. Thank you for your compliments. I appreciate you. And B-Max says, Melanie, I hope every moment of your trip be filled with joy, laughter, and stories you'll cherish for a lifetime. Thanks for being here for 19 months and, make the memories, buy the tickets. I don't just preach it. I actually do it. So there's that. J Love says, I love your channel. Such a role model, a role model. Thank you so much. And Kay Anderson says, how would they get a hold of him if there was a family emergency? Yeah, do it that way. Right. Exactly. Thank you for your 5. Sue T says, why Attorney Maddie calling the Army when not on the case? Should it be Tuxbury? That's a good point. I don't know. Maybe he's got better Army connections. I don't know. Kyle says, 48 years ago, when I was in basic training, a trainee was pulled for a civilian summons. The Army didn't blink. Colin better hope the JAG doesn't catch wind of this. Dun, dun, dun. All right. What we also learned is, before we get on to the Aiden Carney papers, what we also learned is that Brian Tully has filed a motion to quash the subpoena against him. He absolutely 100% does not want to appear for a deposition. And so thank you to the eagle-eyed viewer who sent me this article. Not even an article, it's a website. Hold on, do I see if anything has hit the docket yet? Nope. Okay. Brian Tully is now teaching. He's teaching. He's an instructor for something called Advanced Police Concepts. Let the snark begin. Let the snark begin. Here it is. Advanced Police Concepts. advancedpoliceconcepts.com. Under the instructors tab, look, here's Brian Tully. There he is, mugging for the camera. Not to be confused with mogging, which he is definitely not. He's mugging. Let's listen to this. Here's what they say. Here's the bio. Brian Tully retired from the Massachusetts State Police in 2026 at the rank of lieutenant. When did he retire exactly? When did he put it in his papers? Oh, please. He didn't get canned. He retired. He spent most of his law enforcement career investigating and supervising homicide investigations and has extensive experience in criminal investigations and digital forensics. A recognized expert in cell phone forensics and cell site location information analysis, he has been qualified and testified as an expert witness and was recognized as such by the Massachusetts SJC. Okay. Dude, you're an expert in cell site location information. Then why didn't you collect the cell site location information of every single person inside 34 Fairview at all times on the night of January 29th, 2022 in the early morning hours? I thought you're an expert in that, really? So interesting, isn't it? And remember, Tully signed off on everything. He was the unit commander. Brian served as unit commander of a detective unit, leading a team responsible for investigating homicides, officer-involved shootings, narcotics trafficking, wiretap operations, sexual assaults, and white-collar crime. Yes, it is the Norfolk County District Attorney's Defendant Unit that he was the unit commander of, remember? That's right. Zoe says, remember, he delegated cell tower forensic requests to his buddy Proctor. Wow. Interesting. Max says he's an expert at hiding cell phone information. Well, I mean, both things could be true, right? Because if you know how to extract it, you also know how to hide it. Marta says, Tully is underscoring and highlighting exactly the reason why we know all of them are guilty. This bio tells you everything. Thank you for your opinions. He also served as a shift commander for uniform patrols in the greater Boston area, directing the allocation and deployment of department assets in response to real-time incidents, special events, and public safety concerns, and as a part-time platoon commander of his department's crowd control team. Yep. Brian is a dedicated law enforcement educator with a broad teaching portfolio. He has delivered training on homicide investigations. Excuse me while I laugh. Cell phone technology, constitutional law, search warrants, and hostile behavior threat detection to professionals around the world. He helped develop a hostile threat detection program in the wake of the Boston Marathon bombing and has trained thousands of local, state, and federal law enforcement officers, as well as members of the U.S. military. Well, you did a great job with Proctor. Well done to you, sir. I don't remember if he testified in trial number 1 that Michael Proctor conducted the investigation of the murder of John O'Keefe with honor and integrity, or if that was just Tully. I mean, if that was just Buchanan. He has traveled throughout the country and to Australia, assisting police departments in establishing their own hostile threat detection units. Let me ask you something, Tully. Do you think it's good practice in a homicide investigation for the lead investigator to not even go to the scene of the murder on the day of the murder? Do you think that that's good practice? Right. Thank you, Zoe. Zoe says, hey, Tully. Hey, Tully. Excuse me, Tully. You failed to detect hostile threat within your own team, your own subordinate. Are you kidding me with that statement? Yep. He holds a master's degree in criminology from UMass Lowell with certificates in forensic criminology and leadership policy development, and a Bachelor of Arts in criminal justice and political science from Stonehill College. Brian is also a current board member with the Southeastern Homicide Investigators Association. I think most people can agree, law enforcement or not, that the investigation into the murder of John O'Keefe was quite possibly the worst investigation of a homicide ever. You didn't put that on your resume. And here's what he teaches. Brian teaches digital forensics for APC. See his class here? Oh, let's go to his class. Here it is. Oh, this is his class. Digital evidence, where to find it and how to use it. This is what he teaches. It's a one-day course which will provide detectives and investigators of all experience levels a working foundation to digital forensics and its role in modern investigations. Participants will learn how to identify, preserve, and leverage digital evidence from cell phones, vehicles, cloud services, and Internet of Things devices. I don't know what that Internet of Things devices is, but okay, hold on. You're going to teach them how to preserve evidence from cell phones? Then why is it that Karen Reed's phone was wiped of her location data while in MSP custody, sir? Why is that? Are you the one who advised Proctor to turn his settings to delete everything within 30 days? Because you were wrong about that too. Because everything was still in the cloud. Why is it, sir, that you did not require a phone extraction of Brian Higgins and you just let him bring in his own cherry-picked messages printed up between him and Karen and him and John? Why wasn't he even considered a suspect at that point when you had his messages? I mean, albeit the ones that he chose to give you, but you had his messages that indicated that he wanted a relationship with Karen Reed, that he had no bro code, and that he had no qualms about going after his buddy's girl. And he wanted to know where their relationship was going and what she wanted from him. And do you think I'm hot? In their 2-week textationship. Maybe they did meet up once or twice. And he gave a speech the other night at the Juneteenth gala. And he actually said that he, I mean, it was in, I forget, I'm summarizing. It was in poor form what I did with Karen Reed. But one thing you got to remember is that somebody gave her my number. Somebody gave her my number. Yeah. Did you teach Carino to ignore more than 35,000 or something like that texts of Sandra and Matthew Farwell? Did you do that too, sir? Did you teach them how to extract data before search warrants, like in the Brian Walsh case? Great points, Allie. And as far as vehicles go, why is it that the Garino had such a hard time extracting the data from Karen's vehicle and he had to keep calling Burla? But I think the most important word in this sentence is leverage. Participants will learn how to identify, preserve, and leverage digital evidence from cell phones, vehicle, cloud services, and the Internet of Things devices. How to leverage them. Like Karen Reed's voicemails. Would you teach your officers that it's okay to let Jennifer McCabe delete certain communications between herself and her children before turning over her phone? Would that be okay? Is that something that you teach your guys to do? And then I had to click on, of course, because I do fall into the rabbit hole. What is the Internet of Things devices? Okay. Well, that link takes us to the IBM website. The IBM website. What is the Internet of Things? IoT. The Internet of Things refers to a network of physical devices, vehicles, appliances, and other physical objects that are embedded with sensors, software, and network connectivity allowing them to collect and share data. Oh, you mean you could have figured out who was logged into the Wi-Fi at 34 Fairview at certain times? You could have obtained that data, sir, in your Internet of Things knowledge, and you didn't do that? Why? I mean, you're teaching how to investigate homicides. Wouldn't that be an important part of your investigation? This is cross-examination gold. IoT devices, also known as smart objects, can range from simple smart home devices like smart thermostats to wearables like smartwatches and RFID-enabled clothing to complex industrial machinery and transportation systems. Technologists are even envisioning entire smart cities predicated on IoT technologies. IoT enables these smart devices to communicate with each other and with other internet-enabled devices like smartphones and gateways, creating a vast network of interconnected devices that can exchange data and perform various tasks autonomously. Got to disable all the cookies before we move on. Okay, go away. Go away. Now it wants to freeze up. It doesn't want us to know any more about the Internet of Things. This can include monitoring environmental conditions in farms, managing traffic patterns with smart cars and other smart automated devices, controlling machinery, machines and processes in factories, tracking inventory and shipments in warehouses. The potential applications of IoT are vast and varied, and its impact is already being felt across a wide range of industries, including, let's see if it's that doesn't say law enforcement. As the number of internet-connected devices continues to grow, IoT is likely to play an increasingly important role in shaping our world, transforming the way we live, work, and interact with each other. Well, that's interesting stuff. Oh, wait a second. In an enterprise context, IoT devices are used to monitor a wide range of parameters such as temperature, humidity, air quality, energy consumption, and machine performance. Temperature, remember the temperature of John O'Keefe's phone? Remember? I do. Was it Tully who suggested that Ian Whiffen do the whole freezer experiment? This data can be analyzed in real time to identify patterns, trends, and anomalies that can help businesses optimize their operations and improve their bottom line. Wow, I can't wait for him to be cross-examined on all this stuff. This is gold. Let's go back to his course. But they said right here, participants will learn how to identify, preserve, and leverage digital evidence from Internet of Things devices also. The course covers critical considerations, including search warrant requirements and recent case law. Oh, he's teaching case law too, as well as best practices for working with forensic examiners. Oh, isn't Tully the one? Wait, remind me now, because I might be conflating. Wasn't Tully the one who reached out to Jessica Hyde? Was he? Or was it someone else? I thought it was Tully that found Jessica Hyde and started emailing her about the 227 search, but you guys can remind me. Because he's got expertise in working with forensic examiners, he says. Through real-world examples, detectives will develop the skills to integrate digital evidence into investigative strategies. Attendees will leave with tools, references, and the confidence to handle digital evidence in their own investigations. Topics include, what is digital evidence and where does it live? Digital Forensics 101, cellular phone records, networks, and analyzation. Court presentation, emerging technologies and Internet of Things. Legal considerations, and look, he's the instructor, Lieutenant Brian Tully, retired. Look at all the things that he's going to teach everyone through this course. Wow. So he knows how to do all that stuff. What had happened was they just did it. They just didn't. Because they just didn't care about a murdered Boston police officer. It was more important to just pin it on the girl. Thank you to Kyle Sharkey for sending me this, which is one of the parts of Aidan Carney's motion to dismiss. Motion to impound, I mean. And it is only, I don't know, a page and a half long. So let's take a look at this. And here we go. This is in the Commonwealth versus Aidan Carney case out of Norfolk Superior Court. And this is entitled Defendant's Motion to Impound Unredacted Copies of Supplemental Motion to Dismiss Affidavit and Exhibits. Now comes Mr. Aidan Carney and hereby requests an order of impoundment. They want to impound it. Of the today filed unredacted version of his second motion to compel Michael Proctor's communications, which with incorporated memorandum and unredacted exhibits. He has also filed a redacted version with no impounded material present for the public docket. Oh, cool. I don't have that yet, though. I only have this page and a halfer. As for grounds, defendant states that all redactions are previously impounded material, and the instant motion simply respects prior impoundment orders and maintains the status quo. The unredacted portion is filed under provisional impoundment, seeking the court's approval to impound for the foregoing grounds. Mr. Carney does not waive his ongoing objection to protective orders, impoundment, and his prior motion to vacate impoundment orders. He maintains his position set forth in his prior filings on the matter, i.e., that the information may generate adverse publicity, does not support impoundment or protection from public view. So he's still objecting to the impoundment orders, but he's impounding this for now because that's what the court requires. And he's saying the same thing Rosemary Scapicchio was saying in open court. Why are we protecting this man? Why are we protecting Michael Proctor? He is one of the most racist, bigoted, virulent racists of all time. Why are we protecting him, Judge? Wherefore, Mr. Carney respectfully requests that the court impound the unredacted motions, exhibits, and affidavit respecting prior impoundment orders without prejudice to revisit in the future. File the balance of the redacted pleadings in the ordinary course of business. Schedule the matter for hearing on the instant motion to compel production. They want Michael Proctor's total phone extraction. They don't have it. They're entitled to it, and they want it. And a portion of that is going to be redacted and impounded, and the unredacted version will at some point be available on the public docket. I do not have it yet. And in any event, I have some things to do, so I cannot cover it now. Anyway, thoughts, questions, comments, concerns before we wrap this morning stream. Let's go back to the chat for a moment. Oh, I saw what you said. Jay Love, you didn't need to pay a super chat to correct your spelling to role model XOXO. Thank you. Kyle said, good resign. Post went, nah, pulling his creds. Yeah, I saw that. We went over that the other day. We talked about it the other day. Paula says, in my opinion, Tully should not be instructing anything. Thanks for being here for 4 months. Texas says, why doesn't Karen Reed's attorney send the subpoena to the JAG office instead of relying on Colin's lawyer? Because Colin's lawyer is responsible for producing him. And so the judge directed their attorneys to get him here. So that's pursuant to the court's order. And he's got to communicate with his client. And the judge told him that he's got to come back with some dates of when he's going to be available. Too bad, so sad. Bad timing on your part on enlisting in the Army. Oh, please. Thank you for your 5, Katie. Soap says maybe rubber duckies are a hostile threat. It could be. Could be. Thanks for tuning in from Australia. Marcy's Lies says, what type of company would hire Tully knowing his past? That's a great question. It wasn't me. Thanks for being here for 21 months. Katie said the Internet of Things, IoT, are stuff like smart thermostats, smart washers, and any appliance that connects to Bluetooth or the internet. Thank you. They directed me to the IBM website to read the definition because it's other stuff too. Maybe Apple Health data and stuff. Karen Sutter, thank you, V20, says, good morning. Every time I see you go live, I get a dopamine hit because I know we're getting closer to the truth. Congratulations. Thank you for your 20. Deborah, thank you for your Venmo. Says, tell me you're flying British Airways. They're so great. No, Virgin, actually. I'm loyal. Virgin is a Delta partner. I am brand loyal to Delta because I want my status for next year. Renee, thank you for your Venmo. It says, you rock. The Army has an emergency number. My son graduated boot camp last year. Thank you. And thank him for his service. Stephanie, very generous 100. Thank you. Says, thanks for being on this complex ride with all of us. It's my pleasure. It is my pleasure. Ain't no place I'd rather be, Stephanie. Barbara, thank you so much for your 50. Says, have a nice vacation. Oh, you're great. You're amazing. Thank you so much. As I say to you all the time, buy the tickets, do the things with your kids before they no longer, live with you. Bruce says, my iPhone requires either a code or a facial ID with all the butt dials that went on that night. They must all be butt-faced ugly. You're very funny. You're very funny. I mean, listen, in all honesty, sometimes if I'm putting my phone in my purse or in my pocket, it occasionally, if it hasn't locked, will call somebody. But as you know, if it calls somebody and they don't answer, it goes to voicemail. You have to do another action to hang it up if you want to hang it up before it goes to voicemail, right? Like, we all have common sense, just like our friend Charlie DeLoach, which is why sometimes I put him in the corner, like right now. Because he's needed. His eye roll is needed. He said, Charlie DeLoach said in his interview that we watched the other day, he's like, oh, as soon as I saw the first witness come to the stand, I thought, oh, so this is how it's going to go. And he said, I put my pen down and I didn't take another note. Alan, thank you so much for your Venmo. Just says, thank you for your content. I appreciate you so much. And Oksana, I love you so much. You are very generous. And thank you so much. I intend to have fun. And that's a very funny. Oh, it's a GIF of oh, look who that is. It's the guy, it's Matt LeBlanc putting on a British top hat in a Friends. You're hilarious, Oksana. Oksana is the greatest. She's so beautiful. She's so kind. She has so much common sense. Tanya, thank you for this one that came in last night. So to go to Charlotte Street, lots of restaurants. Speaking of Matt LeBlanc, who I love and I think is hilarious. Have you guys watched, if you haven't not watched the show Episodes, it is one of the funniest TV shows of all time. I don't know where it lives right now, but Matt LeBlanc is in it and he's hilarious. He plays himself. And there's a couple like British comedians who are also in the show and they are hilarious. Thank you, Deborah, for your Venmo. I think I just thanked you. It is so funny. Has anybody watched Episodes? And what do you think about it? If you have watched it. Okay. All right. Stay cool, stay kind, stay classy. Thank you to all of you for sending me your recommendations of things to do and where to go and places to visit in London and restaurants, etc. Isn't it so good? I love it. The US one. Yeah, it's the US version of Episodes. I will be off the air tomorrow through Sunday. So I know you're going to miss me. Try not to. If the Aiden Carney papers drop later today, if I have time and I'm not running around doing a million things trying to get ready for my trip, I will try Can't promise to talk about them later. So make sure your notifications are set. Make sure you smash the like button. Make sure if you're on the replay, you're smashing the like button. Comment, share out the stream. Everything you do helps the algorithm. There is a sale in the merch shop today, 20% off everything. It's going on for, I think, the next week. The link to my merch is in the show notes below, as is my Amazon storefront, where I share all of my favorite things with you, not to buy for me, to buy for you, because self-care is important. Bring your handheld fan, Mel, in the UK. All right. Thanks, coffee drink. I do have one. I'll look for it. I'm be fanning myself in public. Karen says I went to high school with Matt LeBlanc. Oh, you're kidding. Where? Where did he grow up? In California? Thank you for being here for 8 months. I love him so much. He's so funny. And he plays like a really funny version of himself in that show episodes. Take a look for it. All right. So thank you, moderators. I love you so much. Stay cool, stay kind, stay classy. If I don't see you again tonight, I will see you again next week. Because I bought the tickets and we're doing the things and stuff. And Shania Twain is opening for Harry Styles. So how awesome is that? All right, you guys, I will see you real soon, maybe even later today. So make sure your notifications are set and hit the subscribe button. It's free. Let's get the sub count up. Thank you, law girls, not attorneys. I love you guys. I'll see you real soon. Peace out.